If you own real estate in California, you have to have some type of estate plan. As an estate planning attorney, we see this every day in probate court. Someone fails to have an estate plan in place that includes a revocable living trust, and their assets are then pushed into probate court, especially if they own a home, because the value of the home is going to ensure that they have to go through probate. The way that we avoid having to go through probate court when somebody owns real property in California is by having a trust. Having a trust allows them to own that property as the trustee of their trust, and that property would then be titled in the name of their trust. So if something were to happen to them, those assets would avoid having to go through a probate court and just be able to be distributed according to their trust plan. It is important when you are doing your estate plan, when you own property in California, to ensure that you are minimizing the tax implications when it comes to reassessment of property transfers. When it comes to Prop 13 and our new Prop 19 requirements, it is important to understand the requirements when it comes to having that property as your primary residence and then transferring it to a child of yours or grandchild, assuming that you have met that requirement, and then making sure that you have an exemption that's going to be filed called a parent-child exemption to ensure that those property tax rates are then transferred to the child.